Welcome back to the courtroom, where tension rises fast and the judge wastes no time getting straight to business. Today, we're stepping into the sentencing of Jamal Gregory Mosley, a man who already has a criminal history involving drugs, weapons, and probation. But what unfolds here is more than just another firearm by felon case. The judge confronts him with hard facts, the prosecution pushes for prison, and the defense fights for his second chance. And as this hearing goes on, one question becomes impossible to ignore. Has Mr. Mosley truly changed, or is this a repeat of a dangerous pattern? Stay with me, because what happens next shifts the entire mood in this courtroom.
And we now call 24-1683, the state of Texas versus Jamal Gregory Mosley. That is you. And your attorney is Mr. Jeffries. And the state's attorney is here, Mr. Hand. You've seen these already left. Somebody will be here. Earlier, you pleaded guilty to third-degree felony of unlawful possession of a firearm by a previous convicted felon, previously being convicted as a felon. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? And are there any corrections or changes to it? State.
Nothing, state.
And defense.
Reviewed it, no correction, John.
All right, it will be made a part of the record for all purposes. And again, the agreement is a cap of 5 years in prison for this third-degree felony. So you were looking at no less than 2, no more than 5 years confinement in prison. Deferred or unadjudicated probation can be assessed, and I guess regular probation as well. So I have a couple of things here that I received, including what's called a letter on a character reference for Mr. Mosley, and it was signed by Reverend, is it Houston?
Yeah, Houston.
At Ebenezer Baptist Church, and that speaks on your behalf and good things. And then do you work at the oil change place? Okay, I guess the manager there. And that's in Brookshire, Texas, isn't it?
Yes.
I understand, Tim. And it's also is a good reference on your behalf. And I highlighted a couple of things that I wanted to touch base on. Felony. We've got a illegal possession of drugs with intent to distribute out of Jefferson Parish in 2021. And you were placed on probation for that, correct?
Yes, sir.
Was that probation ever revoked?
So,
No. Also, illegal carrying a weapon with controlled substances was a second case out of that event. And you also received probation there. And so I guess those two were not revoked, but it looks like you were convicted, even though you weren't sent to prison.
Right here, the judge highlights something important. Even though Mr. Mosley avoided prison in his previous Louisiana cases, he was still convicted of the same type of conduct, drugs and weapons. This moment matters because it sets the tone for the entire hearing. The judge is signaling that this isn't a first mistake or a lapse in judgment. It's a repeated pattern that stretches across states, and that pattern is going to weigh heavily against any request for probation. Viewers, do you think past convictions should play a major role here, or should a clean record since then matter more?
And that's your criminal history. Okay. Go ahead. Cap of 5 years, and I'll let the defense speak, and then the state can speak. Go ahead.
Your Honor, Mr. Mosley has pled guilty. He's taken responsibility for his actions, and he offers no explanation as far as or excuses rather He knows that the possession of marijuana is wrong. He knows that having a weapon was wrong. And he's looking for an opportunity to grow as an individual and as a citizen.
Does he have credit for this?
His legal issues stem more so from marijuana issues. He has no violent tendencies. He's not a violent person. There's no propensity for violence in his record. And I understand the state's position of not wanting repeat offenders with firearms and the possibility for violence that stems from that. But Mr. Mosley sets himself apart from that in that there is no violent tendencies with him. He struggles with marijuana use, and that's something that we have to address. The PSI that was conducted recognized that he's a low risk on probation and offers or recommends a significant amount of community service, some programming, some counseling, some curfew, all things that Mr. Mosley would not object to in any way. And he has a good support system in place that is now very aware of his issues, including the church family, and including his parents, which are here today to support him, and other ancillary members of the family. And also he recognizes that his behavior directly affects his 7-year-old child, and then that child looks up to him and looks up for guidance and example, and he understands that the past has not been a great reflection on how to behave, and he's asking the court to give him an opportunity to come and grow. Allow him the chance to care for his child while growing, while getting the treatment he needs, and while proving to this court that he can be a good citizen. He has stable employment. He's got good work history. His primary issue is that of marijuana use, and that's something that he knows.
This is a powerful turning point. The defense paints Mr. Mosley as someone with community support, a steady job, and a desire to change, all strong arguments for probation. But here's the conflict. Support systems don't erase repeated decisions involving guns, drugs, and violations of bond conditions. The judge is clearly wrestling with both sides, the human side of rehabilitation and the public safety concerns. And the question hits hard. Does a support system guarantee change, or does past behavior speak louder? What would you weigh more heavily?
He has to get control, and he knows that moving forward, that's just strictly not an option for him.
Anything else?
No. Not this time.
States.
Your Honor, my recommendation is 5 years in the TDC. When we go through this PSI, he's overheard telling the passenger of the car that, I need to keep my gun in the car, which kind of just tells you where he's at in this whole process, which is quite different from the pitch that I just heard from defense counsel. He clearly does have a marijuana problem. He admitted to the PSI officer that he smoked marijuana as recently as the day before his interview. All that is in violation of not only bond conditions, but just being in possession of it is a offense in and of itself. In addition to that, Your Honor will note the substance abuse history that is recorded on page 3.
Yeah.
I just think that the community in general would be safer under these facts and circumstances with the court assessing a prison sentence.
I would just say today that this is not a situation where he's going to go to prison forever. The community is going to be reintroduced to Mr. Mosley, and the primary consideration needs to be rehabilitation. And the probation offers rehabilitative services that far exceed anything that he would be able to be exposed to in a penitentiary. And so the community would benefit more from him becoming a productive, law-abiding citizen through probation other than incarceration.
He was given that chance in 21, Judge.
Well, he's got you on the checkmate on that one.
That's true. He was also
Twice.
He was also early in his early 20s, Your Honor. He's
Old enough to know better.
It's fair.
Yeah, he was put on probation in 21 and for illegal possession. I mean, they made a big deal about it. And you were convicted of it. That's regular probation. Also illegally carrying a weapon. I mean, this is like a repeat performance of what happened a few years ago, as though you didn't learn anything from it. And nonetheless, you can't play this down. Marijuana is intoxicating. You're driving a 4,000-pound missile.
Oh, yeah.
And
Also,
they could smell it. It was reeking
We're gonna collect.
with marijuana. So you're operating a motor vehicle while intoxicated with drugs and illegally possessing drugs. And let's throw this in. You got a firearm in the vehicle, which is another crime. A felon can't possess a firearm.
Your Honor, may I
Go ahead.
interject there? There's no evidence that he was intoxicated at the time of this incident, as much so that the officer released him from it.
Are you disagreeing that marijuana is intoxicating?
I'm not. I'm just
It
saying
reeked with the odor of marijuana.
at the time there was no evidence that he was intoxicated when this incident happened.
I'll draw a reasonable inference from it. Okay. Yeah. You can't play it down. It was made a big deal in 21, which you apparently minimized. And here we are back at the same old thing, only you're now in Texas doing this.
And one fact that I don't think's been mentioned, Judge, is that the firearm was reported as a stolen firearm as well. This was 8 months after his probation ended in Louisiana that he's telling somebody that, I got to keep a gun.
And this is where the tone in the courtroom completely shifts. The moment the prosecutor reveals that the gun found in Mosley's car was reported stolen, everything changes. Now, this isn't just a felon in possession case. It becomes part of a larger pattern of high-risk decisions. Combined with the officer hearing Mosley say he needs to keep a gun in the car, the prosecution argues that probation would not stop the cycle. The tension is real here. Is the state pushing too hard, or are they exposing the exact behavior that threatens rehabilitation?
Car. If I honestly thought there was any reasonable chance at rehabilitation, I would join in defense's argument, but there's not.
What would you like to say, sir? Yeah, this is your chance to say something if you wish.
I'd like to say something, sir.
Go ahead.
Moved to Texas 5 years ago, and I came out here to change my life.
For the better or worse?
But for the better.
Okay, good.
Yeah. That's what I came out here to do. When I was going home, Louisiana, I caught with the weed and the gun. So going home, I was just doing something stupid, going home for no reason. No,
I don't know what you're talking about. Are you talking about in 21?
so the case that's now,
Okay, well, you're playing it down. I mean, you're committing crimes. But you were convicted of the same type of behavior. Those actions have consequences to them. Didn't you learn from that lesson when they placed you on probation? The regular probation. I mean, you were convicted, so it has consequences.
So why would you come over here and do the same thing? Especially when you have a family at home, right? I was hearing something about the child. Well, you can't use a child to protect you from consequences of your behavior. I feel sorry for the child, you. I mean, the child, what's the best gift you can give a child? What's the greatest gift you can give your child?
Be enough for,
Good example, role model.
so,
Is this a role model?
so.
Of course not. I just wish before you got in the car and did this, called Mr. Jeffries, even though you may not have ever known him. And he would have probably given you some good advice and led you through this. He can't. It's hard to clean up a mess that's made, especially when it's the second kind of mess that happened before. That had to get cleaned up. Just understand, and that using it, stating, well, you've got to have mercy on me. I've got a child at home, which you had. You made this choice after you knew it had consequences. That's why I feel sorry for you. I wish you were a better role model. I'm a parent. I can't imagine. It's easy as a parent, if you care for your children, before you make a choice that may adversely affect them, to decide which one is more important to you. You and your drugs and guns, or your child. You made a choice. That was the wrong choice because you were punished the first time. Anything else?
No, Your Honor.
If nothing further, I'm going to find that in this case, Mr. Mosley, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at your plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third degree felony. I'm following this agreement. You're hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. I'm following this agreement. Could have been 10 years, but it's 5 years. You don't have much credit at all here. You would be given credit for any time you have served. But this is the sentence that this court feels is fair and appropriate under the circumstances, especially this being a repeat performance of the same behavior for which you were convicted before. This court has little wiggle room on this. You had your opportunity.
In the end, the judge finds Mr. Mosley guilty of unlawful possession of a firearm by a felon and follows the 5-year cap agreed upon by both sides. The court emphasizes that this sentence is based on repeated conduct, the same actions that led to his earlier conviction and probation. The judge makes it clear that second chances only work when someone learns from the first one, and in this case, the pattern was too strong to ignore. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Time you have served, but this is the sentence that this court feels is fair and appropriate under the circumstances, especially this being a repeat performance of the same behavior for which you were convicted before. This court has little wiggle room on that.